Major breaking news out of the United States Court of Appeals for the Sixth Circuit, which includes Michigan. The United States Court of Appeals has denied en banc review of a major Second Amendment case that I suspect may find its way before the United States Supreme Court next term. This case involves whether or not the right to keep and bear arms includes the right to train with firearms. Stay tuned. We're going to break down this major decision from the Sixth Circuit just today. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Terrorist Attacks by Hamas on Israel teach Americans about the right to bear arms. We must learn the lessons of the importance of armed citizens, privately armed citizens, by looking at mistakes that others have made, including Israel in 2023, by not encouraging private gun ownership the way they should have. They should not have forgotten the lessons of World War II and the Holocaust and the importance of making sure you're armed. But apparently they did, as I laid out in my best-selling book, Israel Disarmed. Check it out on Amazon. All right, major breaking news out of the United States Court of Appeals for the Sixth Circuit. That includes states like Michigan. The case of Oakland Tactical versus the Howell Township. We've covered this case before. Today, the Court of Appeals has denied a request by the Second Amendment plaintiffs to hear this case en banc. To jog your memory, several months ago, a three-judge panel in a 2-1 decision found that basically there is no right to create a shooting range or a gun range, a commercial gun range, in a agriculturally zoned property because it does not implicate, among other things, the text of the Second Amendment. I'll put a link to some information down below. You can get geeky if you want to on that topic. Anyway, the 2-1 decision said that the Second Amendment was not implicated by this lawsuit brought by Second Amendment plaintiffs that said that we want to be able to open and train at a shooting range that includes, but is not limited to, but includes a 1,000-yard rifle range. Because the only thing that's in the neighborhood, and by that I mean that sort of capaciously, broadly defined, if you will, are indoor ranges which really only allow you to shoot handguns, according to the plaintiffs. And they wanted to be able to shoot guns outdoors where they could practice with rifles in addition to handguns. And the zoning laws were such that, according to the complaint, prevented anyone from opening a commercially operated shooting range, including an outdoor range. Nevertheless, apparently, as I understand it, you could do things like operate an airport in the same areas. And yet you could also fire on private land privately, for fun, privately, not commercially, your firearms, including rifles. So despite the fact that, according to the complaint, you could operate an airport in this area of the township, and you could privately fire rifles outdoors in the township, in this particularly agricultural zoned area, the town said you could not build a commercially operated gun range, shooting range, with an outdoor range. And the plaintiff sued, saying that this is clearly a violation of the right to keep and bear arms, because the right to keep and bear arms has a necessary concomitant right, sometimes referred to as ancillary rights, to train. And the plaintiffs in this case cited to language from Heller that talked about the importance of a well-regulated militia. Well-regulated at the time of the founding in 1791 refers to competent, effective. That's what well-regulated means. Well-regulated does not mean what it means in many contexts today in the 21st century, which is like the EPA comes out there with government bureaucrats to regulate your little pond in the backyard as a wetland that requires the U.S. Corps of Army Engineers to mess with you if you decide to do anything in your backyard. That's not the kind of regulation well-regulated means in the context of the Second Amendment. Well-regulated in the context of the Second Amendment simply means effective and capable. And there was discussion in the Heller case in 2008 by the U.S. Supreme Court that says the right to train obviously is part of that. You have to be proficient in the use of firearms to make sure that the textual right, the right to keep, which means to possess, and the right to bear, which means the right to carry, that obviously includes a concomitant right to train, to be proficient in carrying and firing firearms for, among other reasons, the right to self-defense. Now, this 2-to-1 decision actually basically engaged in a form of interest balancing. And this decision a few months ago said essentially that, look, there is no reason why you American citizen, need to know how to fire a rifle at 1,000 yards when the Second Amendment really just requires you to have the right to use a handgun in case of confrontation to defend yourself. So basically they said because the rationale of the panel, if you read it carefully, was basically said because there's no basis and the plaintiffs have no explanation whatsoever for thinking that the right to have a handgun in case of self-defense, in case of a confrontation with some bad guy, somehow gives rise to a right to keep and bear arms, including a right to fire a long gun, a rifle, on a 1,000-yard range. This case involving whether or not the plaintiffs have the right to build and then use a shooting range, outdoor shooting range, which would include a 1,000-yard rifle range, that's not implicated by the text of the Second Amendment. Now, this is clearly wrong, and I'm happy to report that Judge Kethledge, who was actually on the Supreme Court shortlist, dissented from this decision and made it very clear that the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed, is implicated because there's a concomitant right to train found implicitly in the right to keep and the right to bear arms. And because this law by the Howell Township restricts the ability to open a commercial firing range, gun range, shooting range, the text is implicated because it infringes upon, which means to hinder. To infringe means to hinder, based on founding era dictionaries. To infringe means to hinder, and by not allowing for the creation of this commercial firing range, this gun range, it means that the ability not just to run this, but also to train there is being infringed, i.e. it's being hindered. So the right to keep and bear arms and the concomitant right to train is being infringed upon by denying people the ability to create an outdoor gun range in the Howell Township in Michigan. And as a consequence, the plaintiffs argued that because the text is being implicated, the burden shifts, as you know, under the Bruin-Heller methodology, to the government to show historically there is some basis for restricting this right to train. And there is simply no basis for concluding that there is a restriction on the right to train outside of perhaps you're not allowed to train in a downtown area. Obviously, you don't have to, you don't have no right to train with firearms on Fifth Avenue in New York City. That's obvious. But that analysis occurs at the burden shift, and that occurs though at the historical level where the burden is on the government to justify their regulation. It doesn't occur at the textual level where all the plaintiff has to do, the Second Amendment plaintiff simply has to allege that the right is being implicated and infringed upon, interfered with, which clearly it is here, and then the burden shifts to the government. But in this case, the 2-to-1 panel in the Sixth Circuit said that because the text was not implicated, because the right to defend yourself with a handgun in a self-defense situation where you're being confronted with by a bad guy, that's what the right protects, and does not entail a 1,000-yard shooting range. Specifically, this is what the 2-to-1 judges said, the two judges in the majority that said there was no Second Amendment violation. This is what they wrote. Quote, "It is difficult to imagine a situation where accurately firing from 1,000 yards would be necessary to defend oneself, nor have plaintiffs identified one. To the extent that historical evidence is probative of the scope of the right, derived by necessary implication, like the right to train, the historical evidence plaintiffs present, a handful of examples of riflemen making shots from 600 to 900 yards during the Revolutionary War is not convincing." Now, this is simply a bunch of hooey. Because again, it's not rocket science. The text says the right of the people to keep and bear arms shall not be infringed. That text, as we've talked about on this channel and in my articles elsewhere, you know that text includes concomitant or ancillary rights, including the right to train. So once there's an infringement on the right to train, the burden shifts to the government. But you see what happened here is the two judges specifically said that the handful of examples the plaintiffs present, bing, 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 wrong, wrong, wrong. Not even close. Plaintiffs present a handful of examples as not convincing. It's not the burden of the plaintiffs to do anything outside of showing you have a modern-day gun control law that is infringing upon, i.e. interfering with, the right of the people to keep and bear arms, which includes the right to train. That's it. The burden shifts to the government. And then here you have these 2-1 judges, the two judges in the majority in the Sixth Circuit, saying that the plaintiffs, the Second Amendment plaintiffs, fail to come up with history that's persuasive. They don't have to. They literally are like a criminal defendant. Once you're indicted, you just have to sit there and look out the window. If the government bears the burden historically to show that they have a basis for restricting this right to train, and they don't. And here's why we know they don't. Because the right of the people to keep and bear arms, what is not there? What is not in the text? There is no there's no geographical limitation on the right of the people to keep and bear arms. What do I mean by that? Think about it for a moment. The Third Amendment to the Constitution, which says you cannot quarter troops in a person's home, is locationally restricted to the home, right? No quartering of troops allowed in a person's home. That right under the Third Amendment is limited to the home. So too the Fourth Amendment, right? You have restrictions on warrantless searches on a home, on a residence, right? Geographical limitations. There are limitations throughout, but the Second Amendment does not include any geographical or locational limitations at all. So whether or not you're talking about a county or a township or something that's zoned agricultural or zoned residential or zoned commercial, it doesn't matter. The text of the Second Amendment applies everywhere all over the country. There's no geographical or locational restriction like we might see in other parts of the Bill of Rights. And I'm happy to report that the Second Amendment plaintiffs made the proper argument when they sought en banc review from the entire Sixth Circuit, but it was denied. And I'll tell you why that's so important in a few moments. The argument they made is the correct one in their brief seeking en banc review. This is what the plaintiffs in support of the Second Amendment wrote. Because the conduct at issue involved taking a gun to a range to train, it became incumbent on the city to justify the restrictions its rule imposes. The plaintiffs were not required to show that the plain text somehow specifically covered training outside a person's city of residence. Rather, it was the city's burden to justify its restriction, and the city pointed to no evidence of laws in force around the time of the adoption of the Second Amendment that prevented gun owners from practicing outside city limits. Similarly, here in the Oakland tactical case, because there is a right to train at a range, the township must justify its restrictions on range training with history. That's powerful language in the brief, and they're referring, of course, to an opinion by Justice Alito in the context of the first NYSERPA case that was mooted out. So the point is very powerful language pointing out that once the right to train is implicated and burdened in some way, the burden shifts to the government to come forth with history, and there simply is no history that restricts the right to training as a general matter. Of course, that doesn't mean that you cannot have proper zoning requirements that say you cannot set a shooting range in downtown of a city or anything like that. That would be justified based on the history of not allowing shooting ranges like in maybe downtown Boston in 1791, that kind of stuff. That's just basic zoning laws. But this is not the case as alleged by the plaintiffs in the Oakland tactical case. So what's going to happen now? I don't know for sure what's going to happen, but I think this is a case that is a very strong contender for a cert petition. And I think there's a pretty good chance that the U.S. Supreme Court will look carefully at this and clarify that the right to train with firearms is undeniably part of the text of the right of the people to keep and bear arms, and that the burden is on the government in these kinds of cases to justify their restriction with history. So I do think that my guess is you will see a cert petition in this case of Oakland Tactical And I think the Supreme Court will take it seriously, and they may even grant cert in this case sometime in the fall. So when I told you in a prior video that there will be Second Amendment cases before the U.S. Supreme Court in the 2024-2025 term, that's my best prediction. This, I think, is a real contender. And again, strategically, I do think the Second Amendment movement wants to generally get away from fighting about 922G prohibited people cases, because the people in the prohibited person categories, rightly or wrongly, may be viewed a little bit in a negative light by the Supreme Court. And strategically, I think we're generally better off finding sympathetic parties and sympathetic cases where you have good facts to make good law, as opposed to terrible facts like Zaki Rahimi, which was a set of terrible facts, which runs the risk of making terrible law. Even though the Rahimi case itself was ultimately not a terrible decision for the Second Amendment, it's kind of where we expected it to come out. Nevertheless, we will be tracking this Oakland Tactical case as there are continued developments. If there are continued developments, my guess is you will see a cert petition, but I don't know that. That's my guess. And I will report if we see such a thing in the next several months. All right, folks, there you have it. I hope you learned something here today at the Four Boxes Diner. Make sure you subscribe to this channel. We're trying to continue to grow the channel. Make sure you follow me on X for more information about the Second Amendment and other issues. At Four Boxes Diner is the handle. And don't forget to check out my book, Israel Disarmed, on Amazon. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.